The federal appeals court adds a new wrinkle to the legal fight over felony gun rights. Plus, Trump's pollster finds strong voter support for gun rights. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over today to sign up for our free weekly newsletter to keep you up to date on all things happening in the world of gun politics and policy. To kick us off this week, we want to talk about a big ruling out of the Sixth Circuit Court of Appeals dealing with the ever thorny concept of gun rights for felons, convicted felons. This is not the first time that the Sixth Circuit has ruled on this question, but it is the first time since the first time after Bruin, which makes it interesting because the Sixth Circuit has sort of carved a new path in this landscape.
Right. And one that seems pretty in line with how we feel the court might be going, the Supreme Court might be going on this stuff, given oral arguments and the decision in Rahimi, right, the domestic violence restraining order case. Because the court talked quite a lot in that case about dangerousness, right? This dangerousness standard, that seems to be the direction they're headed. They were very skeptical of the government's argument in that case that it was more about, responsible citizens and whether or not you're responsible. You could have your gun rights taken away if you weren't responsible, according to the government. And the court didn't seem to like that concept. They wanted something much more concrete than that. And, they seem to be headed towards dangerousness. Now we've only got the one case from the Supreme Court post Bruin. And that kind of settled on that Rahimi was in fact dangerous, based on the fact pattern in that case. And so we haven't gotten one yet where the defendant was not deemed dangerous according to the court. So we don't know exactly where they're going to come down on this stuff, but they seem to be setting up a dangerousness test of some sort. And the Sixth Circuit here, this whole decision revolves around a dangerousness test, right? Yeah,
that's right. Back in August, they heard basically a felon in possession case. It was a violent felon in that case challenging his conviction. But in that ruling, they sort of took the most, I would say, ambitious leap as far as all the circuits have gone. Most of them have ruled quite narrowly, whereas the Sixth Circuit in this case said, okay, we're going to we have some tea leaves that we can read from the Supreme Court. We're going to try to take the next step and establish our own framework. And that's essentially what they did, is they set up a dangerousness test where they said, under this circuit's case law, we're going to decide when these as-applied challenges can succeed, all hinge on whether there's dangerousness. And so This case, the one that happened this week, was the first time that was actually kind of put to the test. And this
is interesting, right? Because the person who was charged, so these are all cases where somebody already has a felony and then they are also caught with a firearm, which violates the federal prohibition on felons possessing firearms. And so then it comes down to more or less whether the underlying crime, their felony conviction, should be something they can be disarmed for. And here we had somebody who was, I don't know, I want to say technically convicted of nonviolent felonies, but the court went beyond what the specific felony convictions were for, right? And they took a broader view to try and decide whether this guy was dangerous or not, right?
Yeah, that's right. That's why this one to me is kind of a fascinating one, because technically, you're right. He has multiple felony convictions in his past. All of them are technically nonviolent felonies, but he also has a lengthy criminal history that aren't felony offenses, including assault, domestic violence incidents that weren't charged as domestic violence incidences. So they didn't count as a prohibitory offense because that is one of the criteria that can lose you your gun rights. So the court in this case said,
and we say technically here because, I mean, literally they're nonviolent felonies, but they seem to be stemming from situations where violence was involved, and perhaps he pleaded down to something lesser that didn't include the violent aspect. That seems like what's going on when you read the description from the court of what this guy's background was, right? And then there are a bunch of lesser crimes, felonies, misdemeanors or whatever that did involve violent acts in them, right?
Yeah, threatening people with a gun, punching someone in the head, that sort of a thing. And
shooting at people too, right?
At one point, I think that was part of one of his felony charges, which gets to your point about possibly pleading down, because there was all sorts of the court in this case laid out sort of his criminal conduct. And like you said, threatening his family members with a gun and shooting at someone at one point. But that was apparently part of what led to like a burglary felony charge. So that didn't really capture all of the crazy details that went into that crime.
Similar to Rahimi in this.
It's very regard. And they actually comment on that in the ruling, which is interesting. There are a lot of similarities from Rahimi. But the court basically said, you're saying that you should get your gun rights back because these are technically nonviolent felonies. However, we as a court are permitted to look at the totality of your criminal history to get our, reading of your dangerousness. And they said, based on, all of the charges that you've had and all the convictions you've had, you are quote unquote undoubtedly dangerous. And so that's how they were able to arise at the fact that, the felon in possession ban is constitutional as applied to you, even though you're technically a nonviolent felon because you exhibit signs of dangerousness.
Right. And I guess, we mentioned earlier that the Supreme Court hasn't taken up a case yet where the person doesn't meet a dangerousness standard. So we don't really have insight into what they would think, right? That would take, what it would be to be a felon, but not dangerous. And so this is similar in that regard. The Sixth Circuit now has upheld the charges in both of these cases as, because the person was dangerous by their understanding or by the standard that they're using. So, in that sense, it's not, neither of these two courts have set the outer limits of dangerousness yet. But I think reading through this decision and your write-up of it, it sure feels like something the court would agree with, the Supreme Court, based on Rahimi. Like, I think the Sixth Circuit, at least in this particular circumstance, does have a pretty good understanding of what the court is looking for. But there is there's some interesting, workaround, you might call it here, because technically the thing that makes him prohibited under federal law is just the felonies. And federal law doesn't take into account anything else beyond the fact that he has been convicted of felonies. It doesn't care that he had a violent misdemeanor record. That's not what makes him prohibited under federal law. It's his technically nonviolent felonies. And so it is interesting that they are kind of working around that fact to get to the broader picture of who this guy is and whether he's dangerous or not. I would agree with them personally that he sure sounds like a dangerous person, that the Supreme Court probably wouldn't want, and most people probably wouldn't want that guy to be armed. But it does create this kind of odd situation where they're not really judging the statute. They're kind of judging whether or not it's okay generally to disarm this person. And the statute does it in a way that doesn't take into account the things that actually would indicate that he's dangerous. But that, I guess, doesn't really matter to the Sixth Circuit, it seems.
Yeah, it's one of the things that actually sort of widens this whole circuit split that's happening on this question. So even though a lot of courts are coming to the same ultimate outcome, where, in other words, upholding the felon in possession ban, they're doing it in such different ways that it creates its own circuit split. So like you said, the Sixth Circuit permitted itself to look at misdemeanor history and also the conduct surrounding the felonies as criteria for whether or not this person is too dangerous to be armed. Whereas to your point, the statute itself only cares about the felony conviction. It doesn't care about the surrounding conduct. And then other circuits that have looked at this question, the Fifth Circuit, for instance, which has said that as applied challenges are okay. Nevertheless, in those rulings said, well, we're only going to look at the felonies because that's what the statute cares about. So we're going to dismiss other criminal history. So there's differences in how these circuits are approaching it. So it's sort of, to get back to a broader theme of ours, sort of calling out for Supreme Court guidance on this question one way or another. But as of yet, that hasn't shown up.
And, it's interesting because it's almost like the Sixth Circuit is making up a law that would be constitutional, which is one that considers the criminal's entire background when deciding whether or not to prohibit him from owning guns. Because like you said, the law doesn't do that. The law does not care about his violent misdemeanors. The law doesn't care that his felonies are nonviolent, technical or not. So, that's the interesting question there. But I guess, they're doing this as applied to him. And, they're saying, well, in an as applied situation like this, I guess we're going to take the full view of who this person is, to see whether or not they can be permanent. The other difference too, that's important to note as well. I think will come back into play with another story we're talking about later, but the difference between this guy and Rahimi is that Rahimi was only prohibited in that circumstance, at least, temporarily by a restraining order. That, in theory, at least, that was one of the sort of points of contention during Rahimi, was how long, whether or not these restraining orders are really temporary or that some of them can carry on for years and years. But the court ruled that this was a temporary prohibition, whereas the felon in possession law is permanent. Essentially, there's really effectively no way to get your gun rights back for the average felon who's convicted. And so that, while the circumstances are pretty similar between Rahimi and this defendant, the ultimate prohibition is actually pretty different, because it's effectively permanent. And so I don't know. I mean, I don't think that came into play at all in the challenge, right? They didn't consider that the fact that this is a permanent ban. They were just looking at whether or not he could be disarmed.
Right. Yeah. They discussed that aspect a little bit, though, because they made some connections to Rahimi, because that is the only real guidance that they've gotten from the Supreme Court to this point. And they actually put like a multi-page footnote in the ruling where they're basically like, the Supreme Court needs to help us answer this question, because we don't know yet whether permanence or temporary is relevant. They like, to your point, they really harped on the temporary nature of Rahimi.
The Supreme Court definitely seemed to make it relevant, but like
so that was their
guidance beyond that.
Was just asking for the Supreme Court to kind of like, hey, help us out sometime.
Right. So I don't know. Yeah. I mean, because that is an unresolved question about especially the felon in possession ban, which is, I think, as you noted in the piece, like by far the most common gun charge at the federal level is felon in possession. So this is the gun control law. Other things get charged, but not nearly as often as felon in possession does. So it's a pretty huge question. And everyone seems to agree, except for the court, that they need to do more to answer this question, because the Department of Justice and, numerous gun rights groups have wanted the court to take up these cases, and they just haven't done it yet. So we'll see.
Yeah, we'll see. I think it's increasingly inevitable that they will, but you never know with Supreme Court time.
I mean, that's the other thing. Like, it can be very easy to look at, and I've done this a number of times myself. Look at the court, and it's not taking things up immediately, and start to wonder. I think I just had a piece on this. You start to wonder, when are they changing their mind on this question, on this issue? We just had a piece to that effect, right? And but at the same time, it's important to keep in mind that, like, the court functions on a whole different timetable than everybody else. Federal courts move very slowly, generally speaking. Now, they can move very fast. For instance, the court just granted the TikTok case on an expedited schedule. They didn't wait for final dispensation there. They didn't care that it was in an interlocutory posture, is the word that we've used repeatedly on Second Amendment cases. But so sometimes the court does what it wants to do, but generally speaking, they move pretty slow. They like to let the lower courts kind of wrestle with these questions before they jump in to get involved. Even if it seems to people on the outside like the answers are obvious, or the lower courts are are clearly bucking what the Supreme Court wants. They will still take a while. I think, when Bruin first came down, we had Cam Edwards of Bearing Arms on the show. And one of his big points was like, after Brown v. Board of Education, which ended segregation of schools, right, it still took half a decade or more for that to actually percolate down and finally eliminate segregation throughout the country in that way. And, you still had court cases all along the way, and the court wasn't immediately taking up a bunch and tossing. So it's a process. Even in the highest stakes stuff can take a long time.
Yeah, no, that's a good point. Moving on to another story we have this week. You wrote about a new poll that just came out talking about sort of the general feelings around gun rights and the Second Amendment and sort of voters' attitudes toward the new administration and what they want to see them prioritize to that effect. If you want to tell us a little bit about some of the findings of that poll.
Yeah, so this is a poll that was put out by McLaughlin and Associates. And if you follow politics closely, you may have heard of them before because that's one of the polling firms that Donald Trump uses for internal polling. So, just to keep in mind who the poll is coming from. And this is a partisan pollster. So, that's just something to understand about it. And it was also sponsored by these particular questions were sponsored by the Second Amendment Foundation, which is a gun rights group, of course. And so, it's just anytime you're dealing with a partisan pollster or a poll that's sponsored by an advocacy group, it's just something to keep in mind that can play into the outcome of the poll. But at the same time, I don't know that it makes the data completely useless, I guess is the point I'm making here, right? Like, just because this is Trump's pollster and it was sponsored by a gun rights group does not necessarily mean that there's nothing to glean from this. Sometimes that's the case with polls like this, but I'll give a couple reasons why we decided to write this up after I give you the meat of what's in the poll. So first off, it found 77% of voters marked it important, either somewhat or very important, that federal judge appointments try to follow strictly the Second Amendment. So, they're saying that the American voters, this was a poll of voters, value judges who strictly follow the Second Amendment. And then along the same lines, 76% said it was important that their elected officials protect and defend the Second Amendment. Only, there are fewer, I think 17% and 15% in the not important response for those two questions. So, you're just getting a basic trend line here of that voters find the Second Amendment to be something they value. I think that's the takeaway. And then at the same time, the poll found 63% expect Donald Trump to prioritize protecting gun rights. And then also 59% believe that Republicans would do a better job of protecting gun rights than Democrats. So you're kind of getting this, what I take away from the numbers is pretty generalized. These aren't specific questions about policy. They're more questions about, do you value the Second Amendment and who do you think is going to do a better job of protecting your gun rights? And in that case, the answers are Americans do value the Second Amendment and they favor Republicans on the issue, which, like I said, even though this is a partisan pollster or whatever, those results are pretty in line with what you'd expect them to be, right? Like this is something that I think is generally the case. And even though guns, as we discussed all throughout the year, were not a top priority in this election for most voters, it doesn't mean that they didn't have an impact. And the party that won is the party that most Americans believe is more pro-gun. I just think that's uncontroversial takeaway from this poll and from all the polling we've seen up to this point. And, that's why I thought this was at least gives you some insight. And the other half of it is that this is Donald Trump's personal pollster. This is the guy he's used in his elections. He's won 2 of them with the guidance from this polling company. And while they don't get a very good pollster rating from, 538 has them pretty far down the list of all the pollsters they've rated. I think they get a 0.5 star out of 3 stars on the 538 website. And I think they have a 1.1 out of 10 transparency rating for like how they conduct these polls. But at the same time, they haven't always been wildly off from the results. In fact, this election, the last internal poll that the Trump campaign released from McLaughlin, and there's, I think Fabrizio is the other pollster that was doing internal polling for Trump. They released a poll in early October that had Donald Trump ahead in all 7 swing states, which he did win all 7 swing states. And their margins were pretty close. They were within 1 point of the final margin in 5 of those 7 polls. So, the point here is that, yes, I want to be upfront in explaining that this is a Trump pollster. Like, it's his pollster that put this out. It's sponsored by a gun rights group. That doesn't mean that it's that it's completely useless or that it couldn't be accurate, I guess is what I'm trying to get at. I want to be clear as to why why I thought this was worth writing up, because I don't always write up internal polling or partisan lean polls, but we also just don't have a lot of polling on these topics too, is the other thing. So I think it's valuable whenever we get something that's more than anecdotal that we present it to you guys and try to put it in the context of, who's releasing the information. So, plus Donald Trump obviously values this pollster. And so maybe he himself could be influenced by these findings too. That's certainly a possibility.
Yeah, that was the point I was going to make, is like that adds, I think, something to the value of this poll, because like I said, it's very sparse out there in terms of gun polling post-election. We had a few exit polls, not many. And then since then it's been radio silence. So to have a poll and to have it come from Trump's internal pollster himself, obviously says something about how Trump trusts these numbers, which could in turn have some potential policy implications as a new administration is coming in and gun owners and people are watching and excited to see what may or may not happen. These are some of the indications, some concrete things we can actually look to as to what may or may not happen in this upcoming presidency. Yeah, absolutely.
And, and just like when for instance, we talked about Gallup and they had a poll a little while back on like assault weapons bans, but the wording of it was mangled and makes it harder to interpret because of that. And we criticize that when Gallup does it. And the same thing here. Like the question here was, do you think it's important that, federal judicial appointments make it a quote priority to try their best to strictly follow the Second Amendment? Like what, I don't know. That's not a very precisely worded question, right? I mean, so people think it's important that judicial appointments, and then also like the people who are going to be voting to confirm them, make it a priority to try their best to strictly follow the Second Amendment. That's a pretty convoluted way of asking about the gun policy preferences of judicial appointments. Now, I think it gets you to a general, just like the Gallup poll, the question, I think, gets you to a general feeling of what people might think on this topic broadly. But, when the wording is not careful, it can cause issues. That's why I think that's partially why you see specifically assault weapons bans have pretty varied levels of support depending on what poll you look at, right? Because the wording of the question can have an impact. And so these questions are certainly worded, I think, in a way that maybe pushes people a little bit closer to the pro 2A side, just because there's sort of a general agreement that the Second Amendment is a positive thing among most voters. Not all necessarily, but most of them. Whereas if you start drilling down on questions of what people actually think violates the Second Amendment, then you're getting then you'll see more variety in the answers, I think. But so that's why, to me, it's just like the question about Republicans. You think Republicans are better to defend your gun rights than Democrats? Well, most people are probably going to answer that way, because the Republican Party, the way polarization has taken hold in the United States, is the pro-gun party, and Democrats are the anti-gun party. Like, that's how it's worked out to this point. So it's not surprising to see that most people would prefer Republicans to defend the Second Amendment over Democrats. But it doesn't really tell you much beyond that, in detail about it. No, so, there's general takeaways in this. But, what does that mean for the second administration here, the second Trump administration? They, as we covered at the time, notably dropped their gun rights promises from their platform. So they're not really promising much specifically. Donald Trump has made some promises, things like undoing Joe Biden's executive actions. But, beyond that, I think he said he would sign national carry reciprocity, which is very unlikely to actually make it to his desk. But, so there's a couple of things he's promised, but all the stuff that was in the platform got stripped out. And so there's sort of, you're kind of dealing with a more generalized, he's pro-gun, they're not pro-gun field. And it's not this poll and the Republican campaign doesn't really give you an idea of like what voters are expecting from Republicans and what Republicans plan to do on guns necessarily. That's not to say they won't end up implementing pro-gun reforms, because they very well may, but it's hard to know exactly what voters are expecting of them, because they themselves aren't really saying a lot on this topic.
Yeah, that's all fair context, and speaks to the wonderful world of polling. You have to kind of work with what you got in this limited space. So, exactly. But speaking of quote unquote, undoing Joe Biden's gun policy and executive actions, as we get into some of our news links this week, we had a story out of the New York Times talking about the ATF and sort of their bracing for the incoming Trump administration and how that might change the course of the agency. That was sort of the gist of the piece, but it also, I think we both agree, buried a little bit of the big news nuggets that were contained in there, right?
Yeah, they kind of buried the lead on this one in that, according to the New York Times, the ATF director, Stephen Dettelbach, plans to step down before the Trump is inaugurated. So, because technically it's similar to the FBI, the head of the ATF and the head of the FBI are supposed to serve 10-year terms, but Donald Trump has said he would fire both of them. So they're just, I guess, deciding to leave before that would happen. There's a lot of debate over whether that's good or bad or what have you, but it seems that is going to happen here, at least according to the New York Times. I've reached out to the ATF and asked them to confirm that that's the case, and they have not replied to me. So they haven't gotten back to me. They haven't given a timetable. They haven't said anything publicly about this. So I don't know why, but I'll keep asking on that front. But yeah, so the big news to me out of that story was more that Dettelbach is leaving. He also, interestingly, his comments were that he hopes Donald Trump appoints a new permanent director to replace him. Because, he argues that the agency was worse off under a series of acting directors, which it had for a long time, because getting an ATF director confirmed is a bit of a lift these days, given how controversial the agency is among elected officials and their supporters. So, I think that's the big takeaway. The other interesting nugget in there is reporting from the Times, at least. This is just according to the Times' sources. I haven't confirmed any of this myself here. So, just to be aware of what the information, where it's coming from. They claim that Pam Bondi, who we've written about, her background supporting Florida's gun control measures in the wake of Parkland, things like red flag laws. She has been advocating apparently for Trump to appoint somebody who is more of a law enforcement official from inside of the agency, rather than going in a more politicized route like Joe Biden did with Stephen Dettelbach and Shipman before him. So, that's an interesting thought. We also had some reporting out there from, I think Semaphore was the first one to write that Blake Masters, the failed Arizona Senate candidate, is interested in running the ATF and is being considered and making a big push for it. The New York Times named him, along with a number of other potential candidates, including Larry Keene. The New York Times named Larry Keene. I haven't talked to Larry about this yet, so I'll have to see what he says. I have, my sources did say that Blake Masters is making a push for it. So he could be a potential candidate. Nothing's been decided yet. And, the other thing that's in the New York Times piece that I've also heard from my sources is this idea that it's kind of a lower priority, that they may not do anything on this until, at least a few months into the new administration. So you might not have an answer on what exactly Trump plans to do with the ATF until April or May, or, we'll see. We'll obviously be following it. There's no way to really know. And Donald Trump is notoriously fickle about this stuff, and he can make a decision at any time and just announce it himself. That's the nature of him and his administrations. Like, it's not always something that's meticulously planned out ahead of time. Sometimes he just kind of wings it and does it himself. Right. So,
right. And a dark horse candidate could emerge that no one is even considering, because that has in fact happened before with several of these cabinet picks. So we'll have, like I said, we'll stay on top of it, and we'll obviously keep everyone informed when these developments do happen.
Absolutely.
Getting into some of our other newsletter links. One that we just want to briefly mention because it made a big splashy wave this past week is that the attorneys general of New Jersey and Minnesota have gotten into the game of going after Glock for quote unquote Glock switches. They're suing the company because they say that they've done nothing to prevent, people from illegally modifying their Glock pistols. And so it's sort of this new frontier copycat litigation and going after gun companies. It's sort of a trend that's going on for decades, but it's sort of manifested in this new pattern.
Yeah. So it's another one of these laws where it's going to be, or another one of these lawsuits where it's going to be a fight over the Protection of Lawful Commerce and Arms Act, and whether or not these suits are able to find an exception to pierce the shield there for Glock and other gun companies. Essentially the argument here is right that their design allows people to illegally modify it too easily. It's sort of similar to, I think, another lawsuit by the same AG, right? The
Minnesota AG, yeah.
Yeah, against Hyundai and Kia, claiming that they've made their cars too easy to steal. I guess there's kind of that underlying logic if you find it persuasive or not. They haven't had any success yet with these type of suits, so we'll have to see if they can get anywhere or what exactly they would be. Yeah, this is interesting because it's different from the Sandy Hook model, because the Sandy Hook model has become very popular after the Remington settlement. And that was trying to use advertising laws to pierce the PLCAA shield, and it worked at least for a little. To get beyond the very first stages of the lawsuit without it being dismissed. It worked for that. It hasn't resulted in any actual victories in court. The Remington case obviously was settled by Remington's insurers after they went bankrupt. But if that's a win for the advocates trying to pursue these lawsuits, if they can just get to that stage of discovery and move things along as far as they possibly can, that they certainly consider that a big victory in these types of cases. So we'll see if this one, it seems to be taking a different track, trying a different strategy where they're blaming Glock for, I think the idea is that Glock knew that it's somewhat similar to the Smith & Wesson Mexico suit, where the idea is that the gun company was aware that people could do this with their firearms, even if Mexico's argument is that Smith & Wesson and other American gun makers are aware that cartels eventually obtain their firearms and use them to commit crimes in Mexico. So they should be held responsible for that. Whereas here, the idea is that Glock knows that people can make these illegal modifications to their guns and hasn't done anything to change that. Although there's millions and millions of Glocks already out there. I think it is harder to modify the latest generation Glocks with these devices, the switches. But I'm not entirely clear on that. But either way, the underlying claim is basically foreseeability, that, this happens, therefore you're liable for not taking actions to stop it or something along those lines, even if you're not actively involved in the criminal activity itself. That's kind of the logic that they're going with. Yeah, so we'll see if it makes any progress.
That's right. Yeah. Still early stages, but it's worth mentioning just because it does seem to be a new strategy. Obviously, Chicago kicked it off earlier this year with their own suit. And so anytime that these there's clearly coordinated pushes to go after these types of strategies, I think it's worth us mentioning and keeping an eye out for.
Yeah. Yeah, absolutely.
The last link we want to talk about before we wrap up today comes to us from the Courthouse News Service. The Fourth Circuit just held oral arguments in a case sort of similar to what we kicked off the show with, but this time dealing with the gun prohibition for those that have been involuntarily committed. So this is a lawsuit. This is another one of these public defender challenges where a public defender representing a criminal defendant is challenging the constitutionality of the permanent ban for persons who have been involuntarily committed. So this is sort of a less explored frontier in post-Bruin Second Amendment litigation.
Yeah, but it raises a lot of similar questions, right? And then this isn't even an as applied challenge. This is actually just a facial challenge to the prohibition itself, which means that it has a very low likelihood of succeeding, I would think, because you have to prove that there's no circumstance where this is constitutional. And especially with the dangerousness standard that the court seems to be moving towards, it's probably pretty easy to find a circumstance where somebody who's been committed to a mental institution is dangerous enough to justify gun prohibitions under the court's reasoning. I think that's pretty straightforward. But there are, a number of interesting questions that are raised, especially, again, back to the permanent nature of these prohibitions. So, the permanent nature of them raises a lot of questions about, the criminal justice system, our concept of it, and same thing for mental health treatments, because you're essentially saying that these people are dangerous and they will always be dangerous, right? That's one of the key questions, I think, both in the felon in possession, even for violent felons, and then also in the involuntarily committed range. You're essentially saying that these people you can't rehabilitate them whatsoever, or treat them to the point where they won't be dangerous. So that's an interesting debate that I think will have to happen in the courts around these sorts of lawsuits. And then at the same time, if that's the case too, then you hear this critique a lot with red flag laws. If that's the case, that we believe these people will always be dangerous, shouldn't they remain either in prison or in a mental institution? If they're so dangerous that they can't own a firearm, why are they allowed out in society at large? This is a common critique that you'll hear for red flag laws, because red flag laws essentially, in most states, all they do is just take away a person's guns. They're saying you're too dangerous to be able to own this firearm as a threat to yourself or others. But that's sort of the end of the line. You can do anything else. You just can't own a firearm. That probably, it polls fairly well, right? Like red flag laws are fairly popular. And I think felon in possession bans and bans on the mentally, those who've been institutionalized are probably extremely popular, just frankly. And so it's not really a question of political support. It's more of a question of the logic of this. Like, does this make sense? Or do we believe this as a society, that these people both are, one, is everybody who is committed to a mental institution actually a danger to themselves or others in the sense that they shouldn't be allowed to own firearms? That's one aspect. But then two, is there no possibility of rehabilitation or treatments to get the person to the point where they're no longer a danger to themselves? I mean, isn't that the whole question of releasing them? Are they only supposed to be released if they're not a danger to themselves? But obviously, the system certainly doesn't work perfectly. We've seen people who were committed both not have their guns taken away and then go on to carry out attacks. So it's not an easy question. It's just one of those situations where I think these sorts of cases raise questions that aren't easily answered and aren't generally wrestled with in the in the larger media or society, right?
Yeah, no, that's a good point. And I think in particular, it's going to keep coming up as these lawsuits keep percolating up. Maybe not in this one, because like you said, it's a facial challenge. So they don't have to really get into those thorny questions. They can say, well, we imagine some instances where someone is permanently dangerous or whatever. So we'll just dismiss. But to your point, there are probably going to be as applied implications where someone says, raises similar questions. So it's
just interesting to me because obviously our criminal justice system and our mental health systems are both built around the concept of rehabilitation, that it is possible to rehabilitate people or to treat them and to the point where they no longer need to be locked up and restrained, that they are safe enough to release back into society, right? That's the whole idea that we are basing these systems on. And yet it doesn't seem to extend to, it seems like society has been mostly comfortable with the idea that doesn't extend to these people being able to own firearms. And I don't know if maybe that's a compromise we're willing to make as a society, or I don't know. It was just not something we've examined very closely to this point. I don't know what it is. I don't know that there's an easy answer to it. Certainly I would think most people who are committed that happens because they are a danger to themselves or others. But once they're released, I mean, are they no longer a danger to themselves or others? We seem to be kind of two minds about this as a society and how we treat people that fall into these categories. Same for felons, whether their act was violent or not, right? Like if somebody is so, and we've seen some judges go as far as saying even somebody who's committed a violent felony could get their gun rights back. And maybe it's just a matter of making it so that there is a realistic path to getting your gun rights back if you show you're no longer a threat, danger to yourself or others. Maybe that's what we're missing. I don't know. But these are the kind of cases that raise those questions. And so that's why we follow them. We haven't written this one up because our rule generally, just like the Glock switch case, is that we wait to write something up. We have limited resources at the Reload. And frankly, it was not a very good year for membership growth here. But so we have to focus on areas where something has actually happened. There's been a ruling, and that's how we tend to prioritize. But that doesn't mean that there aren't interesting cases, and we try to get that stuff in front of you guys through the newsletter links and these segments on the podcast. So we will definitely be following this case and the others as they continue on through the court system. But I think they raise a lot of really interesting questions at the very least.
Absolutely. And all the more reason for folks to sign up for our free newsletter so you can get those newsletter links that we don't get to in our main stories of the week.
Absolutely. All right. Well, that is all we've got for you guys this week. I think we're going to be off next week for Christmas and potentially the following week too, for the news update at least. I may try to get the interview podcast out to you guys. Which, reminder, if you are a member, which you can go over and buy a membership today at thereload.com if you're not. But if you are a member, you can be on the podcast, the interview podcast. We do a member segment. It's always fun. Just reply to your Sunday newsletter, the members newsletter, and let me know you want to be on. We'll make it work. But yeah, that's all we've got for you guys this week and this year, I guess. So Merry Christmas and Happy New Year. And we will see you again real soon.